Welcome to the first episode of our deep sea mining series. Today I'm joined by my guest, Niloufar Oral, as we explore the origin, the evolution, and the real-world impact of the common heritage of mankind principle. If you've ever wondered what this principle really means, how it differs from the notion of common goods, what covers the notion of heritage, and what this principle truly covers, then this episode is for you. Let's dive in. Niloufar, it's a pleasure to have you today. You wrote one of the foundation chapter actually of the book, and so it was really important for us to have you within this first episode. And the chapter you actually wrote was dedicated to common heritage of mankind. It's a very, very important concept in the law of the sea, but as you pointed out, it has different application and scope also within international law. So the first question is basically, what are the origins and the meaning of the common heritage of mankind concepts, generally speaking, and why it was introduced into the law of the sea in the negotiation in the 70s? Can you tell us a bit more about this, please?
Yeah, thank you, Virginie. First of all, I want to congratulate you for undertaking this book project on a topic that every day grows increasingly important, the International Seabed. So it is extremely timely, and I was really very honored and delighted to be able to contribute one of the, as you say, foundational chapters, looking at a concept that's been around for quite a while, common heritage of mankind or humankind. So the terminology can be updated to reflect somewhat the current times. But, when I was researching this, it was very interesting because we usually associate the common heritage principle with space and law of the sea. But it goes back further, and I bring this out in my chapter, where it goes back to the early years of the League of Nations. And one of the committee of experts, one of the members, Jose Leon Suarez. And he actually was one who, in the report, raised this issue of exploitation and protection of the natural resources, the environment, and the importance of protecting them. And amazingly, saying back then, 1927, the possibility of extinction, looking at, of course, at that time we forget, whales were being overhunted. And so this was also a time where there was great concern about that. So this whole notion that the natural resources of the sea and the oceans belong to all goes back much earlier on. However, having said that, the common heritage, of course, we know that famous speech by Ambassador Arvid Pardo from Malta on the common heritage of mankind. In 1967, of course, it was a different time. And so the concerns he expressed were less to do with the environment, but more to do about development. We know this is also a period of decolonization, where we have new independent states emerging, and the whole issue of the developing states. So it was very much an economic, but a developmental, and you can also say equity issue as well. But it was at the same time linked to the space travel. This was a time when we went into space, the moon. And so there was the issue there as well. Who does the space belong to? Who does the moon belong to? And there it was understood, of course, no one, that we all share it. It's for the benefit of all of humanity. That's the principal idea, that everyone should benefit. There should be a sharing of these resources, including knowledge, the importance of the for example, for the moon and space, also in terms of sharing scientific knowledge as well. So very briefly, that's kind of the background.
It's a really fascinating background because, as you mentioned, it's always been somehow related to resources, commodity. How do we share them? How do we split the economic benefits? How do we ensure equity and a sort of equality among states in the benefits? So it's very interesting. And you mentioned also in your chapter that it's been applied to somehow to genetic resources as well. So we've seen the topic coming back with the BBNJ agreements, but there's been an interesting story with plant genetic resources between the International Undertaking on Plant Genetic Resources and the International Treaty on Plant Genetic Resources, and the evolution between the common heritage of mankind and just the common concern of humankind, as you mentioned.
Yes, and again, this goes back, quite a few years, decades ago, and as it's outlined in the chapter in 1981, FAO, the United Nations Food and Agriculture Organization, there was a request made that an international convention on plant genetic resources be developed. Again, we have to put everything in its temporal context as well, in terms of development and how important agriculture was to development as well, and the role that developed states had in agriculture. And when we say that, it's just not planting the seeds, but the genetic resources of those seeds as well. So I have to say, though, again, we always have this division between developed and developing, and that permeates through a lot of these legal instruments. But so in that undertaking, it was at that time, it was a non-binding international undertaking on plant genetic resources, where the preamble recognized plant genetic resources as the heritage of mankind to be preserved and also said in Article 1 as well. So what's interesting, though, is that later on a binding instrument was adopted, but here, and it included the objective for the conservation and sustainable use of plant genetic resources. It was modeled on the Convention of Biological Diversity, and so in the binding treaty, instead of a notion of common heritage of mankind, instead it opted for the common concern of humankind. And that is what you see also in the preamble of the Convention of Biological Diversity. So I think over time, and in other instruments as well, and it's interesting, for example, the climate change, this notion of common heritage transitions into common concern. And so that's another evolution, although you could see maybe in common concern, it's more sharing the concern, not the resources itself. Anyway, so that's something that was interesting to note.
And there's something also we've seen. I mean, we can see also, usually in the press and in political declaration, they talk a lot about common goods, the ocean as a common good. This is again like a completely different notion. We can't find actually in international law common goods, but how do you see the relationship between this expression, common goods, common interest, common concern? Is it common good more related to what we call res communis and a sort of awkward political translation of what we say in law sometime, or do you see something completely different, this expression being used in the press?
Yeah, it's a good question, because at the end of the day, when we're talking about the common heritage of mankind or humankind, the word heritage, of course, is not about common resources. Common goods is about, tangible resources. It could be intangible as well. And so it seems to imply a whole different level, where the understanding of common heritage is this is something that belongs to all of humanity, and therefore must be protected for all of humanity, including future generations. Common goods is not, I don't see quite that same import. So it's in my mind, it's different. definitely. It's like you talk about we used to have before the European Union, you had the common market, right? Common goods, common market, shared.
Yeah.
So it may be, you're creating some kind of, joint rules for it, etc.
Indeed. And so to come back to the common heritage of mankind in the ocean space, you mentioned in the 70s that it played a very important role as a way to conciliate, the different interests, developing states, to create a mechanism of sharing of benefits coming from exploitation. Is it only applicable to areas beyond national jurisdiction in the area, or is it applicable somewhere else? For people who don't know anything about the common heritage, where does it apply?
Yeah. First of all, it was quite revolutionary. This idea of a common heritage, and maybe we need to go back. We've gone through the history of the oceans from, let's say, the Western, explorer time of trying to divide the ocean. We know the famous Popple Bull, where the oceans were divided. Then Hugo Crotius came and said, no, the ocean and its resources belong to everyone. But the idea was not, of course, quite common heritage, but that other states could not be prohibited from access to the ocean, whether it be navigational or to the resources itself. But common heritage then went a step further. And this is more a shared resource. It's not about you can own it. Well, you can, in the sense that the high seas notion of Hugo Crotius is that anyone can go and fish, right? You can go and exploit, that it was first come, first serve type of mentality. This is what made the difference, particularly for Arvid Pardo, because that notion of freedom of the high seas, first come, first serve, would be a problem when it came to the famous, they call them polymetallic nodules. Now there's more we know, in that seabed that lies beyond national jurisdiction. That's the key. So spatially, it is an area that is beyond where states either have sovereignty or sovereignty rights or exercise control. But it's the seabed area that was. And the whole notion was this now doesn't belong to any state at all, but it's to be used for the common heritage. That means that developing states will also benefit from this, because his concern was that it would be a grab, and that the developed states clearly have the technology, the ability, and it would be to the exclusion of the then, again, we're talking about this decolonization period, they would be excluded and never be able to develop. So it was all tied into development and equity, fairness.
And cooperation, I think, in a way to make sure there will not be further conflict at sea with the grab of resources.
You're absolutely right. Absolutely right. It's about exactly cooperation.
So when we look at the way the common heritage of mankind could be implemented or has been implemented, since there's many different objectives within this notion, could we say that even though there's no exploitation, so no sharing of benefits, there's no implementation of the common heritage of mankind?
You mean at this point?
Yes, at this point. Yes.
Yeah, so if we talk about for the ocean, because one aspect I think I try and bring out in that chapter too is that part 11 of the Law of the Sea Convention, where we have codification of one, of course, the principle of common heritage and its operationalization. I didn't say the word very well, but implementation, which is the point. This is the most sophisticated, detailed mechanism. If you compare it, for example, to the outer space and moon, where the principle is there. There's some, aspects of it, but you don't have a benefit sharing mechanism. You really don't have the detail, the governance detail that you have, for example, whether it be the International Seabed Authority,
Mhm.
so it was very detailed for the ocean. But the point you're raising is the benefit sharing part has not yet been developed, as we know, and there's a reason, because the exploitation part hasn't been developed either. There's a big debate going on. But I have to say, I don't think we would have a Part 11 if we were negotiating the Law of the Sea Convention today.
Of course, yes, I know. Yeah, indeed, indeed. And I agree with you. The level of complexity and of details of Part 11 is really fascinating. And you often hear, actually, when you hear the news or the press, and you often hear that there's no rules actually applicable in this part of the sea. And actually, when you know the reality, it's actually really complex. And on the top of Part 11, you had Agreements 1994, who's been kind of changing, the balance and replacing things, and so basically you have to read the two together and strike some of the parts that are not
Yes, it's true. Yeah.
applicable. So it's really complex, and it's when you compare it, for example, to the continental shelf. The continental shelf regime is really empty if you compare it to what has been actually planned and thought and negotiated for Part 11. It's the governance mechanism is really fascinating. Yeah.
Yeah, it really is. It's again, this has been a project ongoing now for decades, and it has become, I have to say, and I know that the other chapters you will be looking at much more detail, but right now this has become big news, which I think 10 years ago would not have been the case. So the common heritage in its implementation, and that's the key. That is, otherwise the principle is there, fine, but how do we actually bring it to life? What does it mean? And I think that eventually the benefit sharing will be the most fascinating part. And we know, and we may be discussing that later on, but of course we now have the BBNJ Agreement,
Indeed.
which
It actually comes to my other questions, actually, with the various dimension of the common heritage. You mentioned that it has an environmental dimension, and I think it's quite interesting to highlight it, because the way it was designed was, it's mainly famous for its economic dimension, benefit sharing, but it has a very important environmental dimension. Maybe you can say a few words about it to explain, and then maybe explain also, to what extent the BBNJ agreement that was recently adopted provides support or enhance actually the implementation of the common heritage of mankind within UNCLOS.
So absolutely, the environmental aspect is very important, and for the common heritage and the seabed, well, let's just say Part 11. And one thing to understand that too is that we had an important advisory opinion. We are now in the era of advisory opinions, but way back in 2011, it was the first advisory opinion that was submitted to ITLAS, but the seabed chambers, and actually it's in Part 11, the competence to seek an advisory opinion. And so that advisory opinion actually went into detail about the environmental obligations, making clear that there are environmental obligations. And of course, these are all in the provisions of Part 11 as well. So protection preservation of the marine environment applies as well to the seabed and under Part 11. Due diligence obligations, and that came up quite clearly with the advisory opinion, as well as the requirement to do environmental impact assessment. So these are all very presciently put into the part 11, or at least, well, not environmental impact assessment was, I think, the advisory opinion picking up on the pulp mills case, which stated for the first time that the taking implementing environmental impact assessments when we're in a transboundary situation has now become part of the general corpus of international law. So all of these are important. So there's no question, the precautionary approach, there's absolutely no question that protection of the environment is very important and part of the package under Part 11.
Indeed, indeed. And so what is really interesting with the BBNJ agreements, because it applies also beyond national jurisdiction, is that it reinforces, strengthens these obligations of states to conduct environmental impact assessments and to consider many types of impact, actually, direct, cumulative, transboundary,
Yes.
also with the continental shelf. So I think it's going to play a very important role in, reinforcing the body of rules that exist and make sure that states have better tools and know which tools they can use actually to implement their obligations and due diligence obligation, environmental obligations, and the way they can actually protect the area and the resources, actually.
Absolutely. And I think what we've seen is that, going back to my earlier statement, that the common heritage concept, particularly under Part 11, was associated with economic development, equity, even though it includes environmental. But now this notion of common heritage is really expanding into the common heritage of environmental protection.
Mm-hmm.
And I think that's why you see what's happening now in Kingston at the meetings.
Difficult
and this
to
whole
miss
notion, yeah, I mean, we understand much more now than in the 60s. Although in the 60s and the 70s, the environment was, of course, important, and that's reflected in the Law of the Sea Convention, Part 12. I always say it still remains probably the most robust set of binding obligations for protection of the marine environment. But now we can even look at the common heritage, not for common heritage of resource exploitation, but common heritage for protection of those resources, in the broad integrated sense.
Indeed, and we see also the last years, I think also with the negotiation of the BBNJ agreements, we see that there's let's say, will or a push for broadening actually the common heritage of mankind to new types of international law considerations. So, for example, human rights, traditional rights, cultural rights. And we see that it is extremely important, these dimension, especially for small island nation states in the Pacific. When you look at the practice within national jurisdiction, for example, in New Caledonia or in Polynesia, the way they manage the seabed within national jurisdiction is very embedded into the consideration of traditional and cultural rights. And so, of course, there's a push because boundaries are kind of fake invention of lawyers. It will make sense actually to be able to introduce these considerations to the management of the seabed beyond national jurisdiction. So how do you see actually the evolution of the common heritage with regards to the growing importance of human rights, traditional rights, and cultural rights? Because we have this idea of heritage. So I think that's why it's like a call,
Yeah.
The problem is that it was not conceived like this in the 70s because it was economic. But potentially through the synergies, of the different domains of international law, there's something that could open the door to actually implement these consideration into, in another way, actually, in the law of the sea. Will be really interesting.
Yeah, Virginia, that's a very thought-provoking question here in terms of looking at the evolution of this whole the concept, the doctrine, the principle of common heritage. mankind, humankind, we just call it common heritage. And you're right, the operative word is heritage. Well, it's common and heritage. And so what do we mean by heritage? And so heritage includes as well knowledge. And I think when we're talking about Indigenous knowledge, you're right. That is something now that has been expressly recognized under the BBNJ Agreement, which you don't see in UNCLOS. It was a different time. So that knowledge has to be taken into account as well. And so you're right. That could be considered also part of the heritage. Human rights, it's I think that how that fits into common heritage, I actually have to think about that. It's slightly different. It's not a resource per se, but the notion that I think that it's a common right, for everyone, human rights. But we're entering, this is, the BBNJ Agreement and the relationship to the common heritage, it really has taken, now that we're looking to conservation and sustainable use of the ocean, the marine environment, in this once open access, first comes, first serve, huge, vast area of ocean space. It's also, I think, quite revolutionary as well. So we see things changing, and again, you may be talking about that with others, but of course, genetic resources of BBNJ. And the big question there is, how does this principle of common heritage apply to the BBNJ? And I'm sure you'll have more discussions on that, but it's quite fascinating because as I see there's different interpretations.
Yes.
By different countries of this.
Yeah, indeed. How do you, maybe we can finish the interview with this, but the three main foundational chapters of the book have been, I will say, setting the tone of the book, talking about, the history, the importance of concepts, the importance of the role of science, the importance of the precautionary approach, but also the challenges that they face, the scientific challenges, the challenges of implementation of the precautionary approach. What type of challenges do you see happening with the common heritage of mankind, especially when we look at the evolution of technology, science, and environmental shifts? Because as you mentioned, the common heritage of mankind has, of course, an economic dimension, but it's not only the sharing of benefits, and you mentioned in the book, there's also the dimension of, transfer of technology, transfer of knowledge, which has been very poorly implemented under UNCLOS. But it's still extremely important, for states to be able to gain knowledge, to be able to have the right technology, to manage the resources, and not just for exploitation, but also for protection, sustainable use, conservation. So I think there's a lot of very interesting, not only research and studies, but also applications, for this common heritage of mankind in the years to come.
Yes, that's a very big question, and I think your question reflects a lot of the issues, because the common heritage, it's broad, it encompasses various issues. Mostly, it had to do with exploitation and benefit sharing of resources, but there are challenges, as you've outlined, and some of them have to do also with how states are evolving as well. Our notion of developing and developed is changing. You have some very major developing states who, for example, if I can name China, is really, going into the more developed state,
Yeah.
Lots of technology.
Yeah.
And how that will be shared. Technology sharing is absolutely critical, but at a very, very practical level, we have laws. We know these patent laws, these copyright laws. How do we, and this has been always a stumbling block. So the very practical issues of if we really want to share knowledge, share technology, because if the goal ultimately is to equalize a very imbalanced world, economically, socioeconomically, science and science knowledge, knowledge as well. Why does it always come from the West? How do we do that? And this is something that the BBNJ Agreement is very focused on. So these are the very real life challenges we have to face. I don't have answers. It's a big question, but I think it's important to discuss these. And in the sense, start looking into the future. It's not the same world. You know, the 1970s when UNCLOS and Part 11 were developed, different world. As you state, of course, there was the annex that 1994 that was developed for that. You know, but things keep changing, and we see that in the BBNJ agreement as well. Will Part 11 really ever be operationalized? We know, I mean, there's so many issues. I won't open more questions. But we do know also that there are other states who are non-party states, you know, trying to get in on the exploitation aspect, but not the other aspects of responsibility. So anyway, it's turned into one of the most dynamic areas. So there'll be lots to talk about, dear Virginie. So your book is really very timely.
Yeah, and just to bounce back on what you said, I think there's also one fascinating thing that hasn't been much stressed is actually the role of the enterprise, you know,
Yes.
and
Yes.
its relation to the common heritage of mankind. And so far, it's been really left behind. And it's quite interesting to see that there's been so many exploration contracts, you know, going on and still going on actually, because there's exploration going on. But so far, you know, this enterprise and the technology that is needed to actually conduct the exploration and potential exploitation has been, you know, on hold. So there's a lot of questions about, you know, generally the implementation of the common heritage of mankind. I think the enterprise has a big role in the implementation of this concept, and with the interim president, I think it will be quite interesting to see what's coming up actually in the years to come.
Yep.
So,
Yep.
yeah.
Absolutely.
So more work to do.
Always.
Well, thank you so much, Nilufer. It was a pleasure to discuss your chapter, bring, you know, the main your main input and the outcomes of the chapter to light for everyone. And we look forward to having you again, actually, on the episodes, because there will be different episodes. I'm sure we'll have you again. And in the meantime, have a good trip tomorrow back to Singapore. And I
Thank
hope
you.
to see you in person soon, actually. It would
I
be
hope
nice.
so too. I hope so too, Virginia. And thank you again so much. And
Well,
safe travels to you as well.
thank you. Bye-bye.
Bye-bye.